later upload like a more succinct version of that. So today we're just going to do a little bit of research into American law and how American statutes are changing in terms of parental rights. And specifically, we're going to be looking into this case in Montana. But before we start, I want to say thank you so much, Michael. Thank you. Got your super chat yesterday as well. Thank you so much for supporting the stream. Yeah, people like you are the reason that I was able to get a new mic, new camera setup. So let's go. Let's talk about this case. Alrighty. Okay, so this is from the Daily Mail. I saw it on the Daily Mail UK, I think originally, but here we are. So gender ideology has torn a family apart. Montana family lost custody of their 14-year-old daughter after refusing to let her transition into a boy, and it reveals their torment. So we're also going to go over, I had looked up earlier before the stream, like what the Montana statutes are. So we're going to be going into that after this, but let's just go through the story really quick. So Montana mom and dad lost custody of their daughter after they refused to transgender her. They told Daily Mail. This is the girl, Krista, revealed the family's nightmare began when they received a call that their 14-year-old daughter, Jennifer, told friends at school that she wanted to commit S. Later that night, CPS told the family home, Kolstad, I think that's pronounced Kolstad, told the Kolstad home in Glassau to inspect the house and interview Jennifer, later determining that she needed to transition to get better. Krista, who is Jennifer's stepmother and the girl's biological father, had a tough upbringing, undiagnosed mental health concerns. I don't know why that's really necessarily a part of the story. Family will never be the same. I love my daughter unconditionally. And then this is pictures of the family. So that's a little girl transitioning, little girl. Okay. It comes as a family in Indiana has asked the United States Supreme Court to review their lost custody case. They're evangelical Christians who lost custody of their son in 2021 after they refused for religious reasons to start identifying him as a girl. So I find this actually really interesting as well, because I was under the impression that Christian Scientists, there's first of all, we have a First Amendment right to practice whatever religion we want in this country. So I was under the impression that Christian Scientists didn't have to take their children to a doctor. So let's look that up actually, because I'm curious about that now. We'll switch over here. We'll share a new screen. Hold on, let me look it up for y'all. Okay, do Christian Scientists need to take sick kids to a doctor in America? I was under the impression that they had a First Amendment right not to, but let's look into it. Yeah, so there's been Christian Scientists. Christian Scientists are a denomination that teaches healing through prayer rather than traditional medicine and medical therapies. The belief resulted in a number of legal cases against parents of sick children for failing to secure proper medical treatment for them. Similar cases have reached the courts, including Jehovah's Witnesses who refused blood transfusions for their children. States passed religious exemptions to child medical treatment laws. So I guess it's a state-by-state thing. Parents convicted for child neglect and refusing. Okay, the issue publicly resurfaced in 1984 with the death of Robin Twitchell in Massachusetts. Oh, I remember reading about that. Okay. After the 2-year-old died of an obstructed bowel, her parents were charged and eventually convicted of involuntary manslaughter through neglect rather than risk the judgment being upheld on appeal and becoming legal precedent. The church chose not to appeal, which would have been based on the contention that the parents were technically exempt from such prosecution because of their religious teachings. Okay, so they were charged and convicted of felony child abuse. I guess what this is saying is that the church, I don't know how they would know the church's intentions, but it looks like what they're saying here is the church chose not to continue to fight it through the appeals process, because if they did so, this would make new law saying, like, in the future, parents do not have a right to prevent their kids from getting medical treatment. I'm just gonna say hi to chat here really quick. Hey, Mike S, good to see you. Good to see you, Adam. I'm very sorry. Sorry to not help you today. Hey, it's good to see y'all. Thank you so much. Thank you all for being here. I really appreciate it. Okay, so going back into it, it looks like it's a state-by-state basis right now for Christian Scientists on whether or not they're going to be prosecuted for not giving their kids medical treatment. And the reason I was so curious about the Christian Scientists and how this relates to this lawsuit is because the state is essentially the state's argument is that the parents are refusing to give their child necessary medical treatment because the child is so depressed that she wants to commit S. And the reason she's so depressed and wants to commit S is because she's struggling with her gender transition, and her parents are not supporting her in this transition, and that's why they're not getting, like, that's why they're being prosecuted. They're essentially not giving their kid the medical treatment that they need. But I wonder if in the same state, so yeah, let's look up, what state is this? It's Montana, right? Yeah, so let's look up, what are we on? I'll show you. So let's see if Montana Christians not giving child medical. Okay. Yeah, okay. So according to this, Christian Scientists and several other religious bodies depend on prayer instead of medication to treat diseases. The First Amendment guarantees freedom of religion, so anybody is able to give their own consent may refuse medical treatment. However, when parents made the decision for the kid, it raises the question about yada yada. Okay, that's exact. We know that. That's why we looked this up. So parents may be criminally accountable for manslaughter and criminal homicide if their kid dies in medically treatable condition. Most states have decided that religious exemptions for child abuse regulations do not apply in these circumstances, and that parents can and parents cannot be charged? Wait. Most states have decided that religious exemptions for child abuse regulations do not apply in these circumstances, and the parents cannot be charged with manslaughter. Wait, I feel like that's a contradictory sentence. When parents are divorced in different religion, oh, that's really interesting, but that's not really what we're talking about today. Child abuse can take typical forms of child abuse. Okay, child neglect. Yeah. So yeah, most states are going to allow, I don't know, it's split by state. I'm not finding anything on Montana. I guess we could do just a little bit more research on that too. Then I know if we go like this, right? Or plus Montana. Yeah, I'm not seeing anything like specific to Montana. Okay, so let's go back to this case. I was also wanting to look up one other thing that I wanted to look up. So the Montana legal code for separating parents from their children. So this is the Montana, let me make sure, state legislature. So separation, this is separation of marriages. So that is not correct. Separation, what do they call it in Montana? Like dissolution of parental rights? Okay, rights determination, Montana. Okay, so this is not the exact same statute, so we'll take this with a grain of salt. It is a .org, Montana whelp.org. So it is an .org website, but it's not like the actual. Usually, I prefer to look for the actual statute. Oh, but it looks like it's right here, so we'll click on that yet. But let's read this first. A parent can lose their parental rights because of the abuse or neglect. The state can terminate parental rights as part of dependency neglect case in which the abuse or neglect, in which there is abuse or neglect of the child. You can read the law for yourself out here. Okay. So, abuse and neglect petitions, burden of proof, proceedings under this chapter. Okay, so this is for immediate protection, temporary investigation, temporary legal custody. Damn. So these are just all the definitions right here. And then it gets into, after all the definitions, it gets into the law. Termination of parental-child relationship as provided by here. Okay. So may be considered only after filing this form alleging factual grounds for the termination. Is ordered, a court may transfer. Okay. So these are the grounds. Okay, so an affidavit by an apartment alleging that the child appears to have been abused or neglected and stating the basis. So does it have a definition? So here's all the definitions up here. I'm not seeing anything that's like termination. I'm not seeing anything that's clearly defining what abuse or neglect is. I suppose that's in like an earlier part. Okay. So an affidavit, a separate notice, abuse petitions, abuse and neglect, probable cause for the issuance of an order of immediate protection and emergency protective services, or an order for temporary investigative authority, a preponderance of the evidence for any adjudication of temporary legal custody, a preponderance of the evidence for the order of a long-term custody, clear and convincing evidence. It's really not saying anything in here. Like, it's not saying any specific things as to what would qualify, like such as, spankings on the bottom versus like getting slapped in the face. Usually I'm expecting like something more concrete. You can do I can compare like and contrast different cases. So a lot of legal research, the way that you do it is you take legal cases that happened in the past, and you find like one parent who was abused of neglect, but then the court said, oh, they were actually not neglectful because of this fact, and this fact. And then you take another case and the parents are accused of neglect, and the court says, oh, okay, here the parents were neglectful because of this fact, and this fact. And then you're able to take those two cases and compare them side by side. But the problem with family court is that you're not going to have access to a lot of these cases unless they went through the appeals process. A lot of family court cases are just not available. It's like one of the only court cases that, like, types of court that is like extremely private. It is the most private type of court. I'm sorry, y'all. Let's look up this case. Flynn v. Estreves. Okay. Flynn Estreves. 221. Let's see. Yeah, that's what I have here. Present, share screen. All right. Okay, so here, parent guardian. So let's see here. Okay, Patrick Flynn and his wife have 8 children, all of whom attended schools under the control of the diocese to ensure comprehensive Catholic education. Earlier in their lives, some of the older children received vaccinations prior to the Flynns deciding they no longer wanted that doing so is inconsistent with their relationship with God. The youngest, who had not been vaccinated, graduated in 2015 from kindergarten at a Holy Spirit school. The vaccination is different. I know that. Let's see what the holding is here. So this is in Florida. Witness trying to vaccinate. Let's just see what the holding here is. So we're going to skip down to the bottom. This case can be resolved easily and expeditiously under well-settled precedent. The diocese asserted the common good principle as a foundation religious tenet supporting its vaccination requirement. The law does not require the diocese to defend or substantiate its beliefs, but the diocese indicated that it derived this tenet from well-known biblical admonitions to elevate the interest of others above one's own. And that's Leviticus. Although the vaccination requirement may create a moral dilemma for Catholics and others who oppose the development of vaccines using cell lines from the tissue harvested from abortion, that was not Mr. Flynn's objection. Mr. Flynn disagreed with the diocese's common good tenet, instead asserting his contrary belief in the supremacy of what he considered a faith-based, well-formed consensus of parents' right with the respect to matters involving their children, particularly introducing foreign substances into their children's bodies. The trial court correctly refused to become entangled in this dispute. Our constitutional protections, according to their plain meaning and longstanding application, do not allow the government to reject a religious tenet or relabeled as secular in order to subject a religious institution or an individual. So yeah, it's kind of interesting because these are private parties. So it looks like what happened here is a guy wanted to take his kid to a Catholic school. Catholic school was requiring vaccination. Other parents wanted to keep their kid going, and the court decided not to make a decision one way or the other, like not to force the school to let the kids in and not to like punish the parents. So like no decision one way or the other, and that decision to not make a decision was upheld. And the reason being is because there's a separation from church and state, right? And so the government is not allowed to tell the church what to do, and the government can also not tell parents to vaccinate their children. So it's like the government can't tell either party to do anything. The church has a right to religious freedom as it sees fit. And then another thing that I found interesting that they went over on this case is that when you have a First Amendment right to a belief or to like, if you're saying that your religion, like let's say I'm Jewish and I believe that you don't have to circumcise your kids. And then most other Jews say, yes, you do have to circumcise your kids. And I'm saying I'm holding my true religious belief, even though other Jews are holding their true religious belief. The government is not allowed to come in and decide which belief is correct or the correct way in order to have your religious belief. And they're not allowed to look at two people who have the same religion and go, well, if you don't believe the same thing, then one of you is wrong. The government is only allowed to try to determine whether or not you're being genuine in your expression of your faith. What is the line where the belief is absurd and harmful? Right. Well, you're allowed to have absurd and harmful beliefs as long as you're not impeding on the rights of others, right? So it's not. And that's where the vaccination thing becomes tricky, because some people believe that you're impeding on their rights to be able to go out in public if you choose not to get vaccinated. But that's not true in my opinion. I think that everybody has a right to their own bodily autonomy. And if you feel uncomfortable going out in public because other people are unvaccinated, then you have the right not to go out in public. If you have an absurd and harmful belief that eating nails is really healthy for you, the government's not going to stick in and prevent you from eating nails or eating drywall. It's an absurd and harmful belief, but you're welcome to have that absurd and harmful belief, right? And now I think, okay, here's where it goes though. With the First Amendment, if you believe that it's healthy to eat drywall and nails, and you're allowed to have that belief, but you're not allowed to say, I'm a doctor and I have these beliefs, because then you're impeding upon other people's well-being by essentially trying to get them to poison themselves. So that could be an example. Exactly. I suppose you can, if they willingly take it, you could prepare a little dinner for them. But yeah, so let's check out this family anymore. I kind of also wanted to look into their Instagram and like their social media and stuff. So let's see. I'm gonna do that right now with y'all here. Where is that? Let's go like that. Okay, Plano Esteves. So this is the person. I wonder if we could find them on Facebook. Do I have a Facebook account? Yeah, I do. Okay, let's look them up. Okay. I don't know what's happening. Okay. This kind of looks like it. This kind of looks like the lady, right? Yeah, that's 100% the lady. It's totally the lady. We found her, y'all. So this is her Facebook page. We love our daughter beyond words and realize we are in a fight with the government. It only has 11 likes. And their content's not available. Okay. Todd and I were ordered to take our informational video down. The system does not want it made public that it is broken and continues to violate parents' rights. We need to stand together as families, community, protected our family unit. Wait, they made a video? This is a YouTube video link. Okay, let's look at it. Let's watch this video together. Hold on, let me switch what I'm presenting. Share screen. Oh my God. Yeah, it's literally like YouTube took down the video. What the heck, YouTube? Fuck. What the heck? Wait, that's terrible. Okay. Hold on. I'm like trying to, I want to find out about this family. Okay, so 12 years old, think of him. Okay, so I wonder if there's other things that the problem is. I don't want to like hear about this story like 5 years later and then be like, oh, well, she was beating the kid and that's why they were taken away. It wasn't because of the gender stuff, you know? But if she was truly like a good parent, if the parents were good parents and the child is literally only being taken away because of gender ideology, that's not good. Okay, there is not a lot of post here. There's nothing. So I guess this happens like January 16th, so recently. So let's look at Todd. So this is Todd. This is the other parents. Who we have? Okay. Enough is enough. We are seeing this through, and with many good people on our side, the state may have unlimited budget, but we have unlimited love for our daughter and unlimited faith in God. If we truly get held in contempt of court for trying to save the life of our daughter and get arrested, it's better that being held in contempt of God's court. We have been 100% honest about everything. The CPS in Glasgow, Montana, has been dishonest at least 90% of the time. They have said and done, and everything they have said and done, we can and have proved everything already. However, CPS said that truth and facts isn't what's important here. It's how she feels. The judge screamed at my wife, giving her 10 minutes to remove everything on the court. This judge allows, I wonder who the judge is. the judges? Hold on. Okay, CPS in Glasgow, Montana. Let's see if we can find anything interesting about them. Switch. I wish you would switch with me. Like as I switch, I have to stop share screen. Okay. Child and Family Services. Usually, a lot of times they'll have like a Yelp page. I couldn't imagine that any of the CPS pages would have high reviews. I mean, they're literally taking Glasgow, Montana. Let's see. I wonder if they have, I am looking for, okay, definition of child abuse, Montanats. Okay, child abuse or neglect means harm to child's health or welfare, or threaten to harm to child's health or welfare. The term includes harm or threatened harm to a child's welfare by welfare. I mean, these are so vague. So if you believe, I mean, based off these definitions, right? If you believe it's harmful to not give your child gender affirming care, then according to these definitions, you're abusing your child, right? Just because that's your, yeah, that is unprofessional of the judge if it's true. Okay, hold on, let me read. So when a child questions their gender, is that bad parenting or a person just thinking for themselves? When do children get the rights to act on their own feelings, thoughts? Okay, so my opinion on this is that parents do get a right to make decisions for their children up until they turn 18. There are certain rights that you could have as a kid that if your parent doesn't let you, you don't get to. So for instance, like you can have the rights, for instance, to go to like a rated R movie maybe, or a PG-13 movie at 13 years old, right? But if your parent doesn't let you go, your parents have a right not to let you go, essentially until you're 18. So, and then you also have like constitutional parental rights. So from my opinion, I would imagine that a parent can be completely in charge of their child's life until they're out of their custody. When there is a child that's questioning a parent, does that make them a bad parent? I don't think so, because I think there's a lot of parents who try their best. You know, they work really hard. They drop their kids off at school, and then their kids get indoctrinated not only by TV, they get indoctrinated by movies, culture, all of their favorite artists. And then they go to school, and there's no such thing as gender. How do you say? You want to come up and explain that? How is there no such thing as gender? Yeah, I would definitely say that there is such a thing as gender. But yeah, according to what I was saying earlier, according to these statutes, as it appears as we're reading them, it really looks like it's extremely subjective as to what child abuse is, child neglect is. So child abuse or neglect means harm to a child's health or welfare. So if you think it's harmful to a child's health not to get gender affirming care, then if you're the judge, then you would say that the person is neglecting their child. Department emotional abuse means injury to the emotional well-being or intellectual or psychological capacity of a child as evidenced by an identifiable and substantial impairment of a child's physical, mental, or emotional ability to function. Harm to a child's health or welfare means that the harm that occurs whenever the parent or other person responsible for the child's welfare A, inflicts or allows it to be inflicted on the child's physical or emotional abuse. B, commits or allows the committed SA or exploitation of the child. Induces or attempts to induce the child into giving untrue testimony for that child, blah, blah, blah. Causes malnutrition or failure to thrive or otherwise fails to supply the child with adequate food or fails to supply clothing, shelter, education, or adequate health care. See, it is explicitly in the statute adequate health care, but then it doesn't define what adequate health care is. But here's the problem. Like, attorneys are not meant to use common sense, and it's actually good. You don't actually want attorneys to use common sense because most of us aren't very intelligent, and so we don't have any. Not that I'm an attorney, but I mean, not licensed attorney. Okay, but so you don't want attorneys to be like making decisions on what is good healthcare. So instead of relying on attorneys and judges to make those decisions, attorneys and judges listen to what's called experts, and then the experts give their testimony. However, if all of the experts in the health field right now are currently saying that the best way to treat gender dysmorphia is by doing this gender affirming care, if literally all of the experts are saying that, then who is a judge to disagree, right? In fact, even if I were on the bench, I personally know gender affirming care is correct, but if I have literally the only evidence in front of me, which is what I have to go off of, is telling me that I have to take away the parental rights of parents who are not giving their kids adequate health care, and adequate health care includes gender affirming care. Wouldn't my hand be forced? Wouldn't I be required, even if I don't believe this as a judge, wouldn't I be required then to take away these kids from their parents? And if not, be, liable for not really doing my job? So yeah, this is actually really scary. I didn't even realize how scary this situation was until we started doing this research today. And then, I also, what else we should do on this whole research thing? We started going into it a little bit earlier, but when parents divorce, what happens because it looks like the state in Montana, giving your child health care is considered a necessity to not be neglectful, and therefore you're not going to get those exemptions for like the religious exemptions for the Christian Scientists and the Jehovah's Witnesses. Yeah. So what happens if you're married, you have some kids, then you're going through a divorce, and then your wife moves, and let's say you chose a state when you got married, and you decided to have a family, you chose a state in which where Christian Scientists and Jehovah's Witnesses flourish, because the state allows like the ultimate expression of the First Amendment, thus not requiring parents to go seek medical treatment from hospitals when their children are sick. You choose that state, then you get a divorce, right? And now you're divorced, and your wife takes off. Now your wife takes off, and she goes to a state which does require children receive adequate health care, and does consider adequate health care to include gender affirming care. How does that work? So far, from my understanding, from what I've read, states, like, it could be a safe haven, like, for parents who want to take away children from the other parent. So, when did the term gender become so important to certain individuals? I guess like Keynesian, I think it was under Keynesian who was like the sexual education professor, and he differentiated, I think, gender from sex, and even though they're the same thing. Okay. Being the child from divorced parents sucks. You never know when you're getting your allowance from. Yeah. Fair. Yeah, I'm back. I am back. Thanks for being here. Appreciate y'all. So let's actually look into, let's see. Let me take y'all with me. So let's look into taking child after divorce. Okay, during a divorce, a parent who wants to take the child out of Florida. Well, I'm situated in Florida right now, so Google's like, you're talking about Florida, but I just want to know in general. Florida must obtain a written consent from the other parent, but what happens if the other parent doesn't agree to the travel? In that case, the parent who wants to travel out of the state can petition family court. But I do believe there is full faith and credit in family courts. So what that means is, because we live in a we're living in a very interesting country with this federal government, and then the 50 states all broken up with 50 states with their each unique laws. We do have something called full faith and credit, in which we're saying, like, all of the states are essentially agreeing to recognize the rights of the other states and upholding their decisions. So if Florida is saying you're not allowed to take the kids somewhere, then you take your kids to California. California is supposed to uphold Florida's decision, like, hey, you were never supposed to take the kids from the first place. But let's just double check. Okay. Full faith and credit family courts. Okay, a court of the state shall accord full faith and credit to an order issued by another state and consistent with this part enforce child custody determination by a court of another state, unless the order has been vacated, stayed, or modified by a court having jurisdiction to do so. So that's what I'm seeing. Okay, for child custody. Okay. These are the factors for determining child custody. This is, okay, what is a full faith and credit clause? Under Article 4, Section 1 of the United States Constitution, full faith and credit clause is short. It requires the state honor the court jurisdictions of other state. An example of this would be if a defendant runs a red light and hits your car as you're crossing the intersection in New Jersey, and New Jersey judge awards you 50 grand in damages. However, the defendant lives in Texas and refuses to pay you what you are owed. Pursuant to the full faith and credit clause, the state of Texas will help enforce the judgment you collect. Okay. Okay, the purpose of the full faith and credit clause is to apply consistent standard of equality among the 50 states. However, if the full faith and credit clause opposes a public policy of that state, it may not be enforced. An example would be how California permits transgender people to change their gender on birth certificate and state ID in order. So exactly, this is exactly how California has been getting away with it. I knew it. So yeah, I remember reading this somewhere too. Wait, you want me to look this up? 28 USC section. No, I'll check it out. 28 USC. Is this just the full faith and credit clause? Is that what you're, no. Yeah. Hold up. 1738 today. Yeah. Yeah, that's essentially Yeah, that's exactly what that is. Thank you, though. I appreciate you. But I find it very interesting that California, I would argue, you know what people ought to do if they're really concerned about this being an issue, like I'm concerned about this being an issue. Um, what we should do is we should argue that California clause, which makes it public, like if it's part of the state's public policy not to enforce the full faith and credit, to just not do so. I would deem that unconstitutional. No, just be like, well, yeah, we're required. We as a state of California, we're required to, recognize these other state laws, except when we don't kind of want to. Like, how is that not? Yeah, a parent cannot kidnap their own child. Ridiculous. What would you like? I can invite you up here if you want to argue that. I'll put the link in chat. But how are you going to argue that you can't kidnap so if two parents get divorced and the dad is violent and aggressive and beating on mom, and then he threatens to kill the kids, and then he throws them in the truck and drives off. Did the dad not kidnap the children? Is that not what just happened there? You can't. How? What? Okay. CPS could have been very involved before the divorce. CPS could have been very involved before the divorce. Yeah. Men's rights. Don't date a girl with a kid in the state of Washington. Why? Why? Why should you not? No, it's his child. So he's allowed to, like, just because it's your child. But then, so what if he takes the children and he never returns it to mom? You're saying that's okay. People are allowed to parents should be allowed to take the children from the other parent and refuse to let the other parent ever see them again. It's called kidnapping, bro. That literally happened to me. I had sole custody, legal and residential, and my ex-wife kidnapped her and dipped to Memphis. See the yellow spider guy? You have to be empathetic of other people in this chat who may have had their kids stolen, kids kidnapped. That's fucking terrible. That's terrifying. I hope you got them back. Kidnapped her. Well, because you put it in the end. I don't know. Did she come back? Yeah, luckily it was resolved in about 3 Okay, good. I hope you didn't have to put out an Amber Alert. That's really fucking scary. That's terrifying. Sorry that happened to you. Okay. But yes, your kids absolutely could be kidnapped by the other parent. So that's another reason that you need to be careful. So let me have a look. I could have sworn California. Oh, what's it? Sanctuary transgender kids. I could have sworn, yes. Let me share my screen. That is not what I'm trying to do. Hold on. Okay, California is the first state in the nation to create a sanctuary for transgender youth seeking gender affirming care. Governor Gavin Newsom signed the new law in September that ensures transgender kids from elsewhere can safely access hormones. California is the first state in the nation to create a sanctuary that ensures transgender kids from elsewhere hormones and puberty blockers. Legislation also shields families from child abuse investigations or from being criminally prosecuted for seeking gender affirming care. In California, we believe equality. It shields families. Okay. In California, we believe that it's actually really interesting that it shields families because the people who would be suing the families are the kids themselves. So you're saying it's shielding families, but what it's actually doing is crippling children from being able to sue their neglectful parents who put them through a guinea pig type process with sterilization drugs and crazy amounts of hormones and then chopped off healthy members. And now you're handicapping the child from even more by preventing them from going after their neglectful parents. That's wild. In California, we believe in equality and acceptance. We believe no one should be prosecuted or persecuted for getting the care they need, including gender affirming care. Parents know what's best for the kids. They should be able to make decisions around their health. If parents know what's best for their kids and they should be able to make decisions, why aren't they able to make decisions not to give their kids gender affirming care? No? This year, a wave of bills in stating ranging from New Hampshire to Arizona have attempted to limit, ban, or criminalize access to medical care for transgender and non-binary youth. An Alabama law passed in February not only banned medication for transgender youth, but ruled that doctors who break it could face up to 10 years in prison. Yeah. Good. In my opinion. Okay. Scared out of Texas. After decades of building a life in Texas, a mother of 12-year-old suddenly worried she might be investigated for child abuse. So it is going both ways. So it looks like this mom wanted to mutilate her child, which I suppose, do you think parents should have a right to do so? Like, if you and I are saying that we should have rights as parents to not give our kids gender affirming care, do you, like, in the chat, give me a 1 if you think parents should have a right to mutilate their child and give them the gender affirming care if they want, and 2 if no, they shouldn't be allowed to. I don't know. We're suing parents right now. Where was all this shit? Does the CA does California let minors get tattoos with parent? No. I think there are. I think you can get the age dropped a little bit for tattoos. Let me see. Can minors get tattoos in California with parental permission? According to the penal code, specifically 653, the youngest age you can get a tattoo in California is 18. The law, which is part of the legal code of California, permits anyone under the age of 18 from getting a tattoo regardless of parental consent or permission. So no, there's no okay. So some people think, if we're allowed to not give our kids the healthcare, then they should be allowed to give their kids the healthcare. And then other people are like, no, it's mutilating kids. Yeah, I don't have a debate coming up right now, but if anyone wants to debate me on it, I'm more than happy to take on that debate. Just doing research, I found this story really interesting. I wanted to look into these particular parents. Actually, we still haven't done a lot of research into these parents, because I'm just always skeptical of the news too. So if they're saying it's literally just because they're not giving their child health care, I find that very interesting, and I would like to see how the law works on that. And it looks like it would be no issue for a judge to take away the parental rights. Okay, Todd Kolstad. Montana governor defends removal of 14-year-olds. Let's see this. Republican Governor Greg say state officials acted within their legal limitations by removing the child from parents who objected to transitionary gender identity. Montana CPS, CFS, whatever. Officials took custody of the 14-year-old this month. According to Redux, the teenager is reportedly a biological female and recently began to express to his thoughts. While being treated in a hospital in August, doctors began using the child's preferred names and pronouns, which do not correspond with the child's biological sex. According to Redux, the parents reportedly opposed and noted allowing their child to undergo any form of gender transition, social or medically, was violation of their values and morals and religious belief. Doctors reportedly later moved the 14-year-old to a specialized residential treatment facility in Wyoming, despite the parents preferring a facility in Billings, Montana. The parents claim that they were given no information as the child's well-being or treatment during that time, according to Redux. In September, the 14-year-old was returned to Montana and placed in a group home, according to Redux. After 4 months, the parents were reportedly notified that custody was being granted to CFS, and the agency would be allowing the child's birth mother in Canada to ultimately assume care. Oh, wow. So she was an adopted child, too. We were letting the child transition and live as a boy was in her therapeutic best interest, because we aren't willing to follow the recommendation that court gave CFS custody of the child for 6 months. The judge said to us, "You need to expect that reunification with your family may not be what you are expecting." You need to expect that reunification? I think that meant to say accept. The parents reportedly say that they are now exploring their limited legal avenues to fight CFS in the hospital and where their child was treated. Upon hearing recent allegations related to child welfare case, I asked Lieutenant Governor Kristen Juras, an experienced attorney, constitutional conservative, mother and grandmother, to review it. Consulting with the director of DPHHS and personally examining case documents, Lieutenant Governor Juras has concluded that DPHHS and the court have followed state policy and law in handling this tragic case. Our administration will continue to advance policies that strengthen our families and protect Montanan kids, like what we have done to promote adoption and ban permanent invasive life-altering medical procedures on children, like puberty blockers, hormonal treatments, and sex reassignment surgeries, he said. Wait, continue noting a Montana law prohibiting medical. So, wait, hold on. There's also a law hold on. Wait, this is confusing as fuck. Montana law preventing transition. Because there's literally a law in Montana saying that you can't transition a child, and why are these parents in Montana getting in trouble for, hold on. This is in Montana, right? Yeah, in Montana. And then let's go here. What the fuck? Hold on. Okay, an act providing for Youth Health Prevention Act, preventing certain medical and surgical treatments to treat minors with gender dysphoria, prohibiting public funds, programs, property, and employees from being used for these treatments, providing that a healthcare professional who violates this law commits professional misconduct, providing a private cause of action, prohibiting discharge. Wait, what the actual hell? Was this put into place? Is this like an actual Montana bill, or was just a proposed bill? The new language in the bill underlined deleted material stricken. Wait, I cannot tell if this is a passed bill or not. Senate Bill 99. Female gender. They define female means a member of a human species who under normal development has XX chromosomes and produces relatively large, relatively immobile gametes or eggs during her life cycle, like literally defining prohibitions, surgical procedures, including a vaginectomy, hysterectomy. This is literally making no sense. That makes no, so there's literally a bill in place in Montana making it illegal to give gender affirming care to children while simultaneously. Am I reading this wrong? How is this? And then an attorney reviewed this and was like, yes, this makes sense. Multiple attorneys have reviewed this case many times and were like, yes, because I was on that page with them for a moment when I was under the impression that Montana considered it healthcare to do gender affirming care. But if Montana itself also, I can't tell if this is a proposed bill. What a new Montana law means for the transgender children. Families and medical providers in Montana are preparing for a new law to take effect in October. What? That bans certain medical treatments for minors with gender dysphoria. Proponents of the bill say that the law protects children from making medical decisions that they may later regret. This is wild. This is wild. Why is Lauren Daly wearing a big shirt? I'm wearing pants. Okay, thank you. Are you talking about a specific case? Yes. We were talking about this case. I'll bring it up for a second. We were talking about where is it? Okay, now I can't find it. Cool. Love that for me. Love that. Can't see it. Okay, we're gonna just do this. Present, share screen. There we go. Okay. We were talking about this case. 14-year-old girl taken from her adoptive parents and will be given back to her mother in Canada, which is just also kind of wild. Like, the government of the United States is literally shipping a child outside of its borders and just like giving it to some woman that this child probably doesn't even know, right? Holy cow. They're saying they're refusing to transition their kid, but then you have the Montana bill. So they refuse to transition their kid, and therefore they're getting in trouble. And then we went through the statute, and I was like, okay, yes, according to the statute, it is saying that parents can be considered criminally neglectful or negligent or abusing their child if they are not giving them medical treatment. There's none of those exceptions for like the Jehovah's Witnesses, no First Amendment exception for people who believe, who have religious reasons not to put their kid in like in the hospital. Okay, fine. So we've determined that. So therefore, the parents are neglectful if they're not giving their kids gender affirming care, if gender affirming care is recognized by the state as the correct course of action moving forward. However, literally according to the state, according to Montana State, let's share that again. It's against the rules to, this is actually, hold on, where is the actual statute? Where's the actual statute? Where'd it go? I think it's here. Yeah, here it is. Okay, according to this actual statute, an act providing for a Youth Health Protection Act prohibiting certain medical and surgical treatments to treat minors with gender dysphoria, prohibiting public funds, programs, property, and employees from being used for these treatments, providing that a healthcare professional who violates the law commits professional misconduct, providing a private cause of action, prohibiting discharge of professional liability via insurance, and providing definitions. And then it explains, it gives a definition of female, it gives the definition of gender, it gives the definition of male, it gives a definition of minor, anyone under the age of 18. It gives the definition of sex. It gives the definition of transitioning. And then it says you're not allowed to do any of these procedures except for except as provided under Section 1C, a person may not knowingly provide medical treatments to a male minor to address the minor's perception that her gender or sex is not female. Surgical procedures, including vaginectomy, hysterectomy, oophorectomy, ovarectomy, reconstruction of the urethra, metotoidoplasty, phalloplasty, scrotoplasty, implantation of erection or testicular prosthesis. I think that's like saying like fake balls. Subcutaneous, I think that means under the skin. Mastectomy, voice surgery, or pectoral implants. Yeah, so it's this entire thing is saying it literally details in detail what medical procedures you're not. Let's see if it says hormones in here. Hormone. Yeah. You're not allowed to do puberty blockers or cross-sex hormones. And it says that here as well. So you're not even allowed to do this. And yet the judge is taking away the parental rights for not doing this. I find this super weird. Anyone else find this really weird? Okay. Yeah. So I'm confused by this whole thing because how could the judge possibly come to the conclusion that under Montanan law, it is, it is against, link to article. Here's the link to the main article. Put that in chat right now. And then there's another article saying that the governor has reviewed the case and he has had attorneys review it and they believe that it was decided correctly. Oh, did I just send you the same one? I think I just sent you the same thing twice. Let me try that again. Oh. Yeah. And then we can leave it there. Okay. So at the end, I'm very confused by this case because I don't know how a Montana judge could come to the conclusion that is necessary medical health care, that the parents are neglectful for not giving their children, while simultaneously the exact same flipping state has had a statute that's now in effect as of last October saying that you're not even allowed to give those medical treatments. So color me confused. I wish I could find. Can we find? I don't think we have access to the actual case because it's family court and it hasn't gone through the appeals process yet. You only typically get access to the appellate case, and even those could be sealed off, I'm pretty sure, for the benefit of the child. So I'm not even sure. But thank you so much for joining me. I'm going to start trying to stream like every day. So if you want to leave a comment below about how I need to decorate my desk or on what you want to see me stream, let me know. I am talking to Hunter Avalon about having him and Holly come and discuss his recent encounter where he was almost shot by Holly's ex-boyfriend. I'm here with Ian Crossland right now. He's been hanging out. He's taking my dog on a walk right now. So maybe I'll have him on the show soon. So yeah, and plus I'm hanging out with everybody in Ohio soon, and I'm excited for that. Thank you guys so much for being here. When am I going to be on Ricada? Yeah, I still chat with Ricada, so I need to get that going. I've been meaning to do like an attorney-only stream, so I need to get that going. I really appreciate you all for being here. Special shout out to Michael for the super chat in the beginning. Appreciate y'all. Love y'all. Have a good day. Bye.